Welcome to the Superior Court Small Claims Department. This message contains important information about how this court session will be conducted, so please listen carefully. All cases in this court are offered mediation by trained and experienced mediators who are present in court today. Mediation is a process whereby an impartial person works with both sides to reach a resolution of your case that is acceptable to all parties. The mediator does not take sides or make decisions, but will help the parties present their viewpoints in a way that an agreement can usually be reached. All parties here for trial today, where the other side is also present, are expected to discuss the case with the mediators before the judge takes the bench. If a case cannot be settled, the judge will hear the matter and make a decision. If the court file shows that the defendant in your case has not been served with the complaint, we will call you forward for additional information. Service must have been completed 15 days before this hearing if service was made within the county, or 20 days if the service was out of the county. If substituted service was made, it requires 5 extra days for completion of the service. If you have proof of service, present it to the court. If you do not have proof of service, we will give you a new court date and continue your matter for approximately 30 days from now to allow you to have the defendant properly served. When your case is called, please come forward to the front of the courtroom. Bring all witnesses and evidence with you at that time. All witnesses will be sworn to tell the truth at the beginning of the session. The plaintiff presents evidence first, using testimony and physical or documentary evidence to establish the right to recover the damages that have been requested. The plaintiff must also present evidence to establish the amount of the damages that should be awarded. The court may award actual damages according to the proof presented. The court may also award estimated damages, so long as there is sufficient proof of the basis for the estimate. The court cannot award speculative damages, damages for which there is no reasonable basis for the estimate. There can also be no award in small claims court for attorney's fees for preparing or presenting your case, or for your lost time pursuing the matter in court. Punitive damages can only be awarded when there is proof by clear and convincing evidence that the defendant was guilty of malice or oppression in the conduct that gave rise to the matter. At the start of the case, the judge may check to see if the parties agree to any part of the matter. Then the plaintiff is the first to present his or her case. The defendant may then ask questions and present the response to the plaintiff's case. Each side will be allowed to answer any matter brought up by the other side. Before you leave, you will have a chance to tell your side and to present all relevant evidence. The most important rule we have here is that only one side gets to talk at a time. When it's the other person's time to talk, please remain silent and do not interrupt. When it is your turn, they will show you the same courtesy. After all evidence has been submitted, the court may rule immediately or may take the matter under submission. In that case, a judgment will be sent by mail. Please turn off all cell phones and beepers now. Do not read or talk with your neighbor to keep the noise level down. We will be starting momentarily.